Welcome to Excel Academy. In this series of videos, we will discuss some of the important topics under Module 2 of CS Professional Program, Resolution of Corporate Disputes, Non-Compliances and Remedies. Before getting on to the video, if you have still not subscribed to our channel, please subscribe. If you like this video, please press the like button and then share it to your friends. In this video, we will learn about shareholders' democracy. What is shareholders' democracy? Before getting into the concept of shareholders' democracy, we need to understand the concept of democracy first. See, democracy, as defined by many of the authors, it is rule of the people, by the people, for the people. Basically, like here, there is one of the important terminology in the law terms. It is called rule of law. Please note, the end objective of a welfare state, if I have to necessarily talk about, that the country should be ruled by the set of principles and legislations, and the people who are being associated to that particular country should be ruled by the laws. So, that is supremacy of the law is most important. That is the basic concept of rule of law. Under rule of law, democracy plays a very important role, where the people of the country should be involved in the management of the affairs of the country. So, the same concept has to be even included in the company management also. So, here as we all are aware, like company is an independent corporate person, where the management of the affairs will be carried on by the board of directors, and the true owners of the company will be the shareholders. So, the voice of the shareholders has to be respected, and then for the shareholders specific opportunity has to be given for the purpose of getting involved in the management of the affairs of the company, and then they should be involved in the decision making process. So, to ensure that the shareholders are involved in the decision making process of the company, we have come across with one of the important topic here, that is democracy related to the shareholders. So, the company is formed, the democracy related to the shareholders would necessarily mean the rule of the shareholders, what are the decision making capabilities of the shareholders, and the rule basically with respect to by the people, in the sense like by the shareholders, basically they have to come out with some of the important principles, and for the shareholders, for the benefit of the shareholders and all the stakeholders as such. This is what the concept of democracy is all about. So, in the true sense, when it comes to the angle of Companies Act 2013 point of view, what important rights the shareholders are going to enjoy plays a very important role when it comes to promising shareholders democracy. Shareholders should be given an opportunity to speak. Shareholders should be given an opportunity to bargain, as well as establish communication with the management as well as other shareholders. And the shareholders should be given basically an opportunity to form association and then groups, and collectively they should be able to represent themselves before the regulatory authority. These are the three important rights which is required to be guaranteed to the shareholders, so that the shareholders' democracy can be achieved. So, for the purpose of achieving the democracy related to the shareholders, we will find so many important concepts as well as provisions under Companies Act 2013. One of the important provisions under Companies Act 2013, if I have to talk about, are section 179 and 180 of the Companies Act 2013, which is talking about the powers of the board of directors as well as the restrictions on the powers of the board. Please note, the substantial powers of the management will be vested with the board of directors. Generally, all the decision making has to be done by the board of directors. How the board of directors will take decision? By way of passing resolution at the meeting of the board of directors. That is mentioned in section 179 very clearly. But there are certain important items where powers of the board of directors are not sufficient. There are restrictions on the powers of the board. So, you have to take the consent from the shareholders, and then only certain important decisions can be taken. So, those are restrictions on the powers of the board. Some of the important examples on the restrictions of the powers of the board will be like borrowing powers. Up to certain limit, board of directors will have power under 179, but beyond that under 180, for certain important types of companies where the broad base of shareholders will be there, like a listed public company and unlisted public company, for that example, under 180, like if you exceed the limit which is being prescribed, you have to go and then take the approval from the shareholders by way of passing an ordinary resolution or special resolution, whatever the case may be. So, by imposing this particular provision, restrictions on the powers of board of directors itself, one of the important terminology of democracy is getting achieved, where the shareholders are being involved in the decision making process. This is one of the important provision under Companies Act 2013. Going forward in this particular chapter, we will discuss more about all this, what all are the important restrictions on the powers of the board and how the democracy is planning to be achieved. One of the important objective here is to understand what is majority powers versus minority rights. Please note, the shareholders may form groups, because forming association is also one of the important element of democracy. So, when I give that particular right to form association, there should be a kind of restrictions also associated to that. If you see the particular terminology here, for the purpose of passing the resolutions, whether it is a special resolution or ordinary resolution, certain numbers are fixed. So, 51% in number or 51% in number representing 75% of the value. So, whoever is forming part of that particular group, where they will be able to pass the resolution, a special resolution, they would be necessarily called as the majority. So, if the majority have taken decision in a company, then the minority shareholders are basically, they have to say yes, because majority shareholders, if they have passed the resolution, that is binding on the company. So, what are the rights associated with the minority shareholders also we need to necessarily understand. In this context, this particular chapter is completely based on one of the important case law, that is Foss versus Harbottle. Foss versus Harbottle is an English case very long ago which has come up, and then this has based the principle of how the majority powers will be taken into consideration at court of law. Please note, majority powers is one of the important concept which is evolved on the basis of principle of non-interference. The court says in this particular case that if the majority of the shareholders has followed the procedure established by law, they have passed the resolution as required by law, and if they have taken the decision, then the courts will not interfere. Why the court has to interfere? When the time of the court is very precious, non-interference is one of the important principles the courts will follow. So, when the majority of the shareholders have taken the decision, it is really irrelevant for the courts to come forward and then solve the internal disputes of the company, because company is an independent corporate person. But the rule of Foss versus Harbottle cannot be implemented as it is in the Indian scenario. Please note, if majority shareholders have taken decision in the bona fide manner, means with the intent to safeguard the company's management of the affairs of the company, and if the decisions are taken for the welfare as well as benefit of all the stakeholders, then if majority shareholders has taken the decision, that decisions can be protected. So, malicious suits by the minority shareholders can be prevented. But there are some circumstances where intentionally, if majority shareholders wants to do an ultra vires act, that is board of directors as well as shareholders put together, and if there is a fraud which is intentionally which is being committed, or if there are circumstances where the majority shareholders want to oppress the minority shareholders, or there is a gross mismanagement which is happening in the company, these are the circumstances where it will be treated as exception to the rule of Foss versus Harbottle, where the principle of non-interference will not be followed. Okay? So, this is very simple. So, to understand more kind of situations where how the shareholders democracy will be actually provided and what are the circumstances where it is to be restricted, this chapter is very important. If you want to learn more about this particular course, please fill up the Google form which is being provided in the description box below. If you have any questions associated to this particular video, please comment. If you want to know more about the courses offered by Excel Academy, please visit our website www.excelacademy.com. Thank you.